My name is Jessica Saxon. I'm a civil rights advocate and litigator from Washington, D.C. I'm here to provide public notice to you. This is in accordance with USCS Rules of Civil Procedure, as well as Rule 17 and Rule 20 of the United States Supreme Court. The Constitution of the United States of America is the overarching requirements that every state must follow. I don't think anyone here will disagree with that. States cannot enact their own alternative legislation and substitute it for the guarantees of the Constitution. That would mean that your state laws are, in fact, more powerful than the Constitution, and that is unconstitutional. Clause 1 of Amendment 5 states that no person should be held to answer for a capital or otherwise infamous crime unless on presentment by indictment or a grand jury. However, the state of Texas, unfortunately, has enacted its own alternative legislation that permits prosecuting attorney and police officers to charge by way of information as opposed to indictment. That is unconstitutional. An emolument violation is when you pay a public official to commit a crime. There are two areas of the Constitution that enforces this. The first is Article 1, Section 10, where it states that no state shall create any law that shall impair the obligation of contract. So police officers, your prosecutors, your judges, they're all under a contract to perform based on the oath or affirmation that they took. The contract perimeters are in fact defined within the Constitution of the United States. So when a state enacts its own law and directs their agents to disobey that law, that is unconstitutional. The 14th Amendment is the other area where you find the reinforcement of this, and that states that no state shall create or enforce any law that shall abridge the privileges or immunities of United States citizens. Privileges and immunities of United States citizens are at a minimum those that are enumerated in the Bill of Rights and the first 10 amendments. The state of Texas, again, unfortunately, has enacted a law that is in its inferior constitution that is permitting public officials and law enforcement, whom you all pay, to violate the Constitution of the United States. As a result, there's an inordinate amount of people in prison unconstitutionally and illegally here in the state of Texas. Mr. Tanawa Downing is preparing to litigate this at the United States Supreme Court on behalf of more than 700,000 people currently in prison here in America unconstitutionally and unlawfully. I'm here today to notify you that if you continue to pay public officials to break the law, that criminal sanctions can come from that. We don't want that. We don't believe that's the path that anyone wants to go. Nonetheless, officials must be made aware that paying people to disobey the law is an emolument violation, it is illegal, it is unconstitutional, and it is a crime. I'm asking you, honorable individuals, today, please take a look at Clause 1, Amendment 5. Confirm what I'm saying to be true and direct your public officials to act in a lawful, constitutional manner consistent with the obligations that are codified in the Constitution of the United States. I do have a notice that I would like to put on the record. Thank you so much.
Good evening. My name is Tanawa Downing. I'm the civil rights litigator that Ms. Saxon was just talking about. I want to provide just a little bit of clarification so that we can understand what it is that just happened. So if the public officials, your law enforcement, if they're going out and they're relying upon an inferior state statute, state of Texas statute, that permits them to charge by way of information, not indictment, that is illegal. That is unconstitutional because the Constitution requires the indictment by a grand jury. So now there's a crime called deprivation of rights under color of law, Title 18, subsection 242. What that states is that any person who, under the color of any state statute, ordinance, custom, or regulation deprives any person of any rights secured by the Constitution commits that crime. So this is a per se crime, which means that we don't have to prove that they intended to breach their obligations. Simply by virtue of the breach, all elements of crime have been met because their willfulness and their knowledge derives from a promise they make. When you make a promise that you will fulfill a future outcome, you must fulfill that. And if you don't, then you've already implicitly invited punishment in the form of perjury should you fail to fulfill the promise. We're not here to get anybody into trouble. That's not what this is about. This is about bringing awareness to an issue that really needs to be changed. But when that law enforcement officer then arrests the individual unconstitutionally, takes it to a judicial officer and asks that judge to hold the person over for that offense, that judge also has a duty and responsibility to make sure that the power that he exercises is consistent with his constitutional obligations. So when he chooses to conspire by and between the officer, now you have another crime. It's called conspiracy to deprive of rights. That's Title 18, subsection 241. These two crimes composed results in a judgment or an outcome that is wholly and factually unconstitutional because it derives from that unconstitutional arrest. Now, I know that you guys are going to go to your city attorney after this. You're going to ask them, is this true? Is what he's saying real? And that city attorney is going to say to you, well, no, not really. And they're going to point to a case from 1884 called Hurtado versus California from the United States Supreme Court. And before you guys choose to rely upon that as the foundation, I want to remind you that the Constitution of the United States of America is the foundation, not a judge-made ruling. The Supreme Court of the United States has no constituted authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution because it must be done by an authentic act of the people in accordance with the special amending procedure of Article 5. Any other way would be an unconstitutional act. Furthermore, judges have no authority to be able to legislate. We all know that, right? That's because the separation of powers defined within the Constitution of the United States, Clause 1, Article 1 says, all legislative power is vested in a Congress of the United States consisting of a Senate and House of Representatives. So let me be clear. I'm not trying to change the laws. Rather, I'm pointing out what the laws state and that the ways in which they're being enforced directly contradict with what is specified. Therefore, I'm not trying to change the
20
laws.
seconds.
Rather, I'm asking that we uphold them. If the laws state that something will be done in a certain way, we must follow that way. Laws do not change arbitrarily. That is tyranny. Constitutionalism demands that the laws evolve only through suffrage. Therefore, it's up to the people to decide whether or not the Constitution applies to them and not a judge or a state. Thank you guys so much. God bless.
Thank you.